Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about what happens if you commit a crime. And if you do, even if it's many years old, you might be placed into removal proceedings, you might be placed in detention, you might be deported. Okay, however, what a lot of people don't realize is that in certain situations, uh, you actually might be a U.S. citizen and you don't know it. Unfortunately, a lot of people, most people think that if you are not born in the United States, that in fact you are not a U.S. citizen. However, the reality is it is possible, depending on the particular case, that if your mother or father were born in the United States, and sometimes even if your grandparents on either side were born in the United States, that you could derive citizenship based upon the fact that they were born in the United States. So therefore, whenever somebody comes into my office and they essentially tell me, they're in removal proceedings or they committed this or that crime, and or that they're not in removal proceedings but they committed some crime a long time ago, and they want to know, if they're going to have problems coming in, leaving the country, if they're going to have problems naturalizing, petitioning, other family members, renewing their green card, all sorts of things could flag immigration to put them in removal proceedings. Um, the first thing I always do in my typical intake questionnaires is I say, well, were either your mother or father born in the U.S.? Were either of any of your grandparents born in the U.S.? And then there's also the possibility if the mother or father naturalized. So they don't even have to be born in the U.S., but if they naturalized and became a U.S. citizen at a certain point in your life, then it's possible that you might be a U.S. citizen by acquiring U.S. citizenship through their naturalization. So there's the interesting thing about looking at this is it's not the current law as of today generally that rules this. When you're looking for derivation or acquisition of citizenship, you look at the particular law in effect at the time when the event which might give you citizenship occurred. So it's an interesting area where, when, for example, when I'm preparing the briefs or the applications, I do have to go back to the relevant law at the time that existed at that time, and it does change periodically. And so, as you might guess, if you are a U.S. citizen, you have no right, the immigration has no right to deport you. They just have no jurisdiction over someone who's a U.S. citizen. So sometimes when people are taken into removal proceedings and the case is going forward, and I find out that there is a possibility of U.S. citizenship, I'll make a motion to terminate the immigration court proceedings, and if the burden has been met and if the judge sufficiently believes that you're a U.S. citizen, the case will be terminated. Now, I have to make clear, though, if the case is terminated, that doesn't mean, boom, you're automatically, everybody in immigration is going to think you're a U.S. citizen. It's just sufficient proof has been made. Now, you could be a U.S. citizen after all said and done, but if you don't have the necessary proof of it, then it doesn't help you much. I mean, for example, if you leave and go on vacation and come back and you do not have a U.S. passport, you could argue up and down that you're a U.S. citizen, but the officer at the port of entry is not really in a position to analyze and certainly will not make the decision and say, oh, you're right. Under Section 320 of the Immigration Nationality Act, I do believe you're a U.S. citizen. No, that won't happen. So even if you're in removal proceedings and the case gets terminated, the immigration attorney should still apply for a U.S. passport for you or a certificate of citizenship through immigration. Either one will do. I personally think the U.S. passport's probably the better way to go. And it's sent in, and if it is approved, if they believe everything you're saying type thing, and you've provided sufficient evidence, then they will send you a U.S. passport. And there's been cases where I've had people who were 65 years old in removal proceedings, and they've been only to find out that in fact they are a U.S. citizen, and then got the case terminated, got their passport, and everything went well. So with these types of cases, there are requirements, different requirements, depending on when it is that you might have attained the citizenship, and some of it depends on whether your mom or dad were married, whether or not you were illegitimate, whether or not whoever it is that got the citizenship lived in the U.S. a certain number of years before you were born, whether they lived in the U.S. a certain number of years after they turned 14. There's different requirements. Sometimes the physical presence is necessary as 5 years, sometimes it's 10 years, and obviously, especially if the grandparents, one of them or both of them, were born in the U.S., and we have to prove physical presence. That's quite difficult because back then there certainly aren't a lot of documents to prove it. So it's through declarations and other types of evidence. And if you're a U.S. citizen, you are. It's just a matter of proving it. And especially if you're in removal proceedings, and for example, if you have an aggravated felony and you have no forms of relief, certainly trying to apply for U.S. citizenship, if you qualify, is the better way to go. So if you like the video, click like, subscribe, and go ahead and give my office a call. You can get an initial free consultation, and then we'll go from there. More on the coming videos.